Huge victory for the Second Amendment today in Nyserpa versus Bruen, just as I predicted on this channel for you. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, best-selling author, and constitutional attorney. And if you haven't subscribed to the Four Boxes Diner already, please do so and help spread the word and show your love for the Second Amendment by subscribing, liking, and sharing this video. Huge news today. I'm sure you've read it. I've been on the media all day today. It's been crazy. I'm going to post some of my media appearances on this channel just so you can check it out. I was actually on my way to Iowa to participate in GunCon over at Brownell's facility this weekend, and I had to turn around from the airport when the Supreme Court issued this Nyserpa versus Bruen case. So I raced right back here, and now I'm rushing to get this information out to you. I'm only late because the media appearances have taken up a lot of time today, but I haven't forgotten you. Here's what we're going to talk about. Okay, here's what you need to know. Key points. Number one, as I predicted, the Nyserpa versus Bruen decision by Justice Thomas, who I said would write the opinion. What you saw that. He wrote the opinion 6-3. It is 6-3. All the justices agreed with the opinions articulated by Justice Thomas in the majority opinion. We're going to talk about the concurrences and the dissents later, just so you're aware of those issues. Not huge deals, but something to be aware of. The main decision by Clarence Thomas and the court says, you and I have a right to bear arms, to carry arms outside the home for the purposes of self-defense. That's right. As we've talked about, the right to keep arms is the right to possess arms, to have them. That was the question of what Heller and the McDonald cases involved in 2008, 2010. The right to have, to possess firearms, the right to keep. This case, Nyserpa versus Bruen, found that it interpreted the right to bear arms, to carry arms. And the Supreme Court said not only does the text of the Second Amendment mean what it actually says, that the right to bear means you have the right to carry arms in public, but the history of the United States also corroborates the same, that throughout American history, Americans have the right to carry guns in public for peaceable, defensive, proper purposes. And the Supreme Court reaffirmed this long-standing understanding. Okay, that's the first thing. The second thing, again, I've talked about on this channel. I think this decision actually is a vindication of why you watch this channel. The second thing is this, the standard of review. Remember how I told you that tiers of scrutiny, very, very bad for gun owners. Tiers of scrutiny means balance your rights away with judges, meaning they take the benefits to the public from a gun control law and the harm to your individual rights, and they balance it out. And inevitably, these government judges, because judges that work for the government, find that the statute that restricts your gun rights is constitutional, and they uphold it. Huge news and great news for our team. The Supreme Court said that those balancing tests, those tiers of scrutiny, are unacceptable as a matter of constitutional interpretation involving the Second Amendment. Instead, and we've talked about this on this channel before, so if you've been watching this channel, you are indeed the smartest person in your room involving the Second Amendment. The Supreme Court said that the proper way to interpret the Second Amendment is what we've said on this channel repeatedly, which is the text of the Second Amendment first, and then the history associated with that text. Here, the Supreme Court said that the text of the right to keep and bear arms means you have the right to carry, and the history associated with it is the same. But they outright rejected any balancing test. They said the Second Amendment was already a balancing test originally, and the only way to amend that would be through Article 5 proceedings, Article 5 processes, get rid of the Second Amendment, which obviously is not going to happen. So the good news is those balancing tests that I've been warning you about, the tiers of scrutiny tests, the Supreme Court said, no way, no how are they allowed to be used in the Second Amendment context. Another huge win in favor of the right to keep and bear arms here in America. And the third point I want to make is about, remember, I also warned you about sensitive places. This is my greatest concern. We've talked about this many times. Sensitive places was a phrase that was used by the Supreme Court in the Heller case. And sensitive places is an exception to your right to carry guns, because sensitive places is a euphemism, a metaphor, if you will, for gun-free zones. And in the Heller case, it said that there are instances where guns can be banned from being allowed into sensitive places, such as government buildings and schools. Well, the Supreme Court today flagged that as a way for the anti-gun movement to try to exploit and take away our right to carry guns with this exemption for sensitive places. And the Supreme Court narrowed that, probably in anticipation. They specifically said in their opinion that you cannot just declare that all of Manhattan, for example, all of New York City is a sensitive place and have that be constitutional. That's unacceptable. What the court then said, and this is why I think it's a huge narrowing from what they referenced in Heller, the Supreme Court in this opinion said that sensitive places may constitute, ready? Legislative chambers, basically the U.S. Capitol and state houses where they pass laws, one category. Category number 2 of gun-free zones or sensitive places are courthouses. Category number 3 are other places such as polling places. Again, voting and polling in favor is part of the government process. So it seems to me that if you look at what the court is getting at as to what is a legitimate sensitive place, gun-free zone, it's limited to government activities, polling, voting, legislative activity, courthouse proceedings, and maybe schools, although it's a little vague there because, of course, you have private schools and public schools, and we know that from the history, as I've talked about on this channel before, there is precedent for saying that students may not carry guns on campus, meaning a school could ban students from carrying guns based on the precedent we've talked about with Thomas Jefferson and the Board of Trustees at the University of Virginia at its founding. They banned students from carrying guns on campus, but of course they allowed adults who were not students to carry guns freely. And of course the concern there at the founding era was that the students at the University of Virginia, they were concerned they were engaged in dueling and shoot each other to death in dueling contests. And that's why the University of Virginia and Thomas Jefferson said no guns on campus at UVA. But that, of course, is not a major precedent because, again, it allowed adults, non-students, to carry guns on campus. So those are the 3 big takeaways. You have the right to keep and bear arms today. You have the right to carry guns under the Second Amendment. The second thing is balancing tests are no good. Its text and history is the standard review or criteria. And the third point is that sensitive places concern did get narrowed and addressed by the Supreme Court, which I think is very good news because already we've seen statements by New York Governor Kathy Hochul and Eric Adams, the mayor of New York City, talking about how they want to label all these things like bars and taverns and restaurants and places where there's more than 5 people as a sensitive place, gun-free zone. But based on this decision today, it doesn't look like that's going to be doable because there's no reference to private actions. There's no reference to taverns. Of course, taverns were ubiquitous at the time of the founding. They were everywhere at the time of the founding, and there's no historical evidence that you weren't allowed to bring guns into a tavern at the time of the founding. So it seems like the anti-gunners are going to have a very heavy lift here to try to, take away your right to bear arms. I'm sure they're going to try. The only thing I think I should mention is keep in mind there was 3 justices that dissented, and if you read their dissent at the end of the day, it's really the typical anti-gun rhetoric. It just sounds like it's just by a court. They're essentially just saying that, criminals use guns for bad purposes and people die because of guns. And the truth is people don't die because of guns. They die because of people misuse guns, which is not the same as guns causing the problem. That's people use guns to cause crimes and problems, but people also use guns to protect themselves and their families from evildoers, as we know. So bottom line is, this is a very big day for the Second Amendment. I'll be getting out a lot more videos going forward. And again, a lot of my media appearances I'll be posting so you can continue to learn. But the good news is the things that we've been talking about for the last several months on this channel, thank God, have largely proven true. And I think that's great news for all of us. So again, if you haven't subscribed to the 4 Boxes Diner, please do so. And again, we'll see you soon at the 4 Boxes Diner.
Orders up. Table 2A.